Trevor and Jenny Hicks, whose daughters were among the victims of the Hillsborough disaster, are campaigning to correct official court records that inaccurately state their deaths were swift.
Had we had the Hillsborough law, and at the time that we're campaigning for now as well, and a team of public advocates who could have got us the evidence that we needed right at the very start, we wouldn't have had to have waited 24 years for the truth and 26 years to get the correct inquest verdicts. That's cruel.
Medical evidence at the time, known as the 30-second rule, inaccurately suggested all victims were unconscious within half a minute, including Victoria, 15, and Sarah, 19. Later investigations established victims were conscious for longer periods.
So in any case at all where there were early factual assumptions which were incorrect, and where the court record relies on those wrong factual assumptions, in any case like that, a Hicks rule would make a difference. Now that could be relevant in any kind of mass disaster where there was an original mistaken assumption about what happened, but also in any individual case where someone has died and the underlying factual basis is proved to be wrong. So really this could apply in a whole range of circumstances, whether it's a mass disaster, whether it's a death in a mental health hospital, whether it's a death in a prison.
Counsel for the Hicks family, Keelan Gallagher, KC, says South Yorkshire Police could rectify official records by reading a statement in open court, but the force has so far not agreed to a new hearing.
So the very simple route that's available relies on South Yorkshire Police's consent. And if they don't consent, then it's much, much more difficult for Jenny and Trevor. Then there's all sorts of obstacles in their way. And that's why we would then need to get a change to the legal and policy framework to make clear that even if you don't have the consent of a defendant, that a family in these circumstances can still make an application to the court. And to do that, we need a change to primary legislation or a change to the civil procedure rules. So there's got to be a legal and regulatory change if South Yorkshire Police don't take the very simple step, which they could do today if they chose to.
Chief Constable Lauren Pulteney acknowledged past errors and apologised, but did not offer a court correction.
We've heard these comments lots of times, and we've had tea and sympathy loads of times, but action speaks louder than words. We're told there's a simple solution, so let's take action and follow that simple solution.
The Hicks family campaign aims to highlight the wider challenge of correcting official documentation when new evidence emerges, and has drawn attention from political figures including former Prime Minister Theresa May and Greater Manchester Mayor Andy Burnham.
Now, in fact, what Jenny and Trevor would like to get is a change in their individual case, but also a change for everyone else, for all the other bereaved families at Hillsborough, and also for other bereaved families who may be faced with a false court record that they want to correct.